Well, hello everyone, and welcome back to AJ507 Ethics in Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's lecture is going to cover Chapter 10, where we're going to take a look at ethical misconduct in the courts and some of the responses, meaning, here's what happens and how do we deal with it. So, we have a lot of content to cover, so let's go ahead and just jump right in. So, what we hope to learn would be to identify or detail the different types of misconduct that have been associated with defense attorneys, prosecutors, and judges. Explain the reasons why such misconduct occurs. Describe the Innocence Projects and take a look at how many individuals have been found to be wrongly imprisoned and why. Discuss some proposals to improve the justice system and reduce this misconduct, and then describe some of the concepts that are associated with judicial activism or constructionism and how this issue relates to ethical misconduct. And we'll learn those definitions, judicial activism or constructionism, as we go through the chapter. So let's go ahead and just kind of get going. And reading the cases described on the Innocence Project's website or even on the exoneration registry is kind of difficult because it truly is disheartening. Because when you read some of the things, you find out while the criminal justice system in the U.S. is far superior to probably almost anywhere in the world, you still have issues. It's still not perfect, and you become aware of some of the things that contribute to these issues, like laziness or bias or tunnel vision or even ambition, that might lead some of the criminal justice actors, the prosecutors, the defense attorneys, the judges, etc., to maybe commit some actions that might contribute to an innocent person being incarcerated. And so, when you look on that website and you have a chance, remember that it's a great system that we have in the United States, but we know it's not perfect. We know there's issues because we deal with people. And when you deal with people, a lot of times you have ethical issues. And that's really kind of what we're getting to here, if you will. So with that being said, as we kind of move into the section, it is true that more attention is given to the misconduct of the prosecutor and judges than that of defense attorneys, right? And this of course is not to say that defense attorneys are more ethical than the other two groups, but except for public defenders, defense attorneys are not public servants, right? So they're not held to a higher standard. So if you're a private attorney, you have standards, but you're not held to the same standard as maybe a public defender who works for the governmental or the city or state agency. So it's interesting when you kind of look at the two groups of legal professionals. Now, one of the major complaints about defense attorneys is that they really don't communicate regularly with their clients. And, and this basically happens. Sometimes attorneys meet with clients only right before the hearing or other court appearances. So they kind of come in quickly and then go out. And perhaps most neglect here occurs because of these really, heavy caseloads, if that makes any sense. And defense attorneys, especially if you're a public defender, they have a huge caseload, you guys. And we really have to understand how many cases they might have. And sometimes they don't get a chance to review those cases. There's just a big stack of cases, and they actually go through them on the day that, hearings are supposed to take place. Now, complaints received by bar associations generally involve clients who believe that they're not getting what they paid for, in that attorneys don't return their calls, don't keep them informed about what is being done on their case, and really, don't seem to be putting, any effort in the case that, after they've been paid. And this is true for civil attorneys as well. However, criminal defendants are kind of helpless, right? Because they might be in jail. So they really don't have that many avenues or options to get with their clients. And as I said before, some attorneys meet with their client only, right before a hearing or another court appearance. And again, perhaps, we're talking about this issue as it comes to caseloads. And many attorneys operate in this crisis management mode, whereby the to-do list every week can only accommodate those tasks that are, at that deadline date, right? So it's kind of like, let's look at it this way. Maybe we'll look at it with your homework. If you're taking several classes and you only have so much time, and maybe you work and have other obligations and you try to squeeze things in, so you do what needs to be done first, that's due like today, like right now. And it's kind of the same thing, and that can contribute to issues down the line. And the result of this is really some cases don't get that attention that they really need. And that's how things start to kind of, slip through the cracks. Now, one of the most often cited reasons for false convictions, in addition to eyewitness testimony, okay, which is really number one, if you will, is ineffective assistance of counsel. And, the legal standard for what constitutes ineffective counsel is set quite high. And if you just kind of think about it in your mind before we actually go further, what do you think in your head would merit ineffective counsel? But it's really set pretty high. That bar is actually pretty high. So let's look at some of these things that fall into ineffective counsel. So cases identified by the Innocence Project include defense attorneys not bringing forward alibi evidence or other exculpatory evidence. And exculpatory means evidence that might prove their client or show that their client might be not guilty. Next would be cases, also include those defense attorneys who did not challenge testimony of jailhouse informants. So, that's important, right? Because jailhouse informants, those people are in jail. But a lot of times jailhouse informants do have good information. But here, defense attorneys should really be challenging some of this. Next could be, poor defense that a conviction occurred with little or no evidence against a defendant. So again, these are all kind of ineffective counsel type issues. Now, there are some other behaviors that were reported of lawyers in capital and other cases as it relates to things that have kind of gone on or what have you. And this could be attorneys that are under the influence during a trial. Attorneys letting the defendant wear the same clothes described by the victim, and that kind of makes sense, right? Why would you do that? Attorneys admitting that they didn't know the law or the actual facts of the case. Attorneys not being able to name a single death penalty case holding. So they don't have enough knowledge of the law, if you will. Or again, attorneys drinking heavily each day of the trial and maybe even being taken into custody. So all of these things are issues that have kind of been identified, some through the Innocence Project that I just covered, and some of these other ones that have been identified as well. So, one state appellate court said that if a lawyer wasn't sleeping during a crucial part of the trial, it wasn't ineffective counsel. Now, you have to kind of think about that, right? So basically, if the attorney can kind of stay awake, then hey, that's good. And that's really kind of really sad, right? When you think about it, hey, if you're just awake, then you're good to go. But if you don't take notes, don't do anything, don't object, don't cross-examine, don't do anything, that really is ineffective. And most misconduct by defense attorneys probably falls into the realm of what we call negligence, not necessarily criminal behavior. Okay. So, and we'll kind of get into, some of the prosecutorial misconduct here in just a few minutes. So again, as I kind of mentioned a couple minutes ago, these are some of the other behaviors reported of lawyers in capital and other cases, and I kind of already covered those, so I won't rehash them. Sorry, I got a little bit ahead of myself. But again, here's kind of a list as well of some of the things that attorneys that can cause misconduct. Now, it is important to recall that the duty of prosecutors is to seek justice, not convictions. And that truly is the duty. And even so, prosecutors want to win, right? I mean, they do. And there are typically few checks and balances or monitors on their actual behavior. And when prosecutors forget that their mission is to, protect due process, not merely win cases, that's when misconduct can really kind of bubble up or occur. And, the types of misconduct range from, minor lapses of ethical rules to the commission of criminal acts. And most prosecutorial misconduct involves unethical or illegal means to obtain convictions. Not necessarily what they call, pecuniary graft, if you will, meaning like taking bribes and things like that. It's more of the unethical way that they go about to obtain their conviction. And hopefully that kind of makes sense. So it's not like getting free gifts and I'm going to do this. It's more of the manner and the means in which they get the information, the evidence, etc., in order to obtain the conviction. So hopefully that is kind of clear. Now, there's no real source that has an accurate accounting of the number of cases that are basically messed up, if you will, by prosecutorial misconduct in any jurisdiction. Various investigations have uncovered hundreds of instances where prosecutors either commit unethical acts or even break the law. So let's look at some of the misconduct, though. And again, this is on a very, very minute scale, but it still occurs. So that's why we're really discussing it. And it's important that we know this. So one could be withholding exculpatory evidence, both testimonial, meaning things that people say, witness statements, etc., or physical evidence. And remember, exculpatory means what? It means that this evidence might be beneficial to the defendant. And under certain laws, we know the prosecutor has to turn over to the defense any type of exculpatory evidence, right? But sometimes they might just hold on to it when they really shouldn't. Next could be misleading jurors as to the meaning of evidence, so kind of confusing them a little bit. Next, suppressing expert witness reports, even when they were exculpatory. And then withholding evidence that pointed to the culpability of perhaps their witness. So they have information that shows that their witness isn't that credible, etc., but they're not going to turn that over. All right, so these are all, misconduct issues. And, Kirchner in 2009 also discusses 4 kind of broad types of prosecutorial misconduct. It's very similar to basically what we've kind of come to know, right, as some of the different types of misconduct. But this particular author really discusses 4 major types of misconduct. And the first is the same as in the last list, withholding that exculpatory evidence. Misusing pretrial publicity. Because do you think it's possible that you can skew the jury as they watch things on TV or social media? Next, using false evidence. And then finally, using preemptory challenges to exclude jurors. And in any type of a case, depends whether it's if it's a death penalty case or not, etc. Anyway, you are allowed so many challenges when you do voir dire on witnesses, and that's where witnesses, you ask them questions. This is before the trial. And so you're picking your jury, and there's something called voir dire, and built into the system as you pick your jury of 12, and typically in California that's what it is. It could be different in different states. You are given, as a prosecutor and a defense attorney, a certain number of preemptory challenges, which means that you can release a juror and not have them sit on the jury for any reason whatsoever except race. If you just don't like the way they look, you don't think they're going to fit into your scheme or your defense or your prosecution. Now, there's also challenges that are based on bias, and those those are typically unlimited. So those are called challenge for cause. And if there's cause, then you can eliminate someone from the jury. But these preemptory ones, you only get so many. And we'll learn a little bit more about that, so I don't want to confuse you. But you're using these challenges to eliminate a certain, juror that maybe the defendant is, let's just say, Hawaiian, or whatever race. It really doesn't make a difference, or ethnicity. And so you're excluding this person from the jury because maybe you don't like that particular person, or their ethnicity, their gender, whatever. So that's kind of enough on that. I don't want to spend too much time. And here's a super interesting case that should make you think when you talk about, misconduct, etc. So this is the case of Curtis Giovanni Flowers. And here's a man who's been tried 6 times in the state of Mississippi for murder in the July 16th, 1996 shooting deaths of 4 people inside of a furniture store. And the victims were the owners and 3 employees. And we don't have to go through all their names, etc. Now, as we go a little bit further, 4 of the trials resulted in convictions, all of which were overturned on appeal. And he was first convicted in 1997. Think about that. And in 5 of the 6 trials, the prosecutor, this individual by the name of Doug Evans, sought, the death penalty against Flowers. And as a result, he was held on death row in the Mississippi State Penitentiary for over 20 years. Now, let's kind of go back. In his first trial, Flowers was convicted of the aggravated murder and robbery of the store owner. The verdict and conviction in a second trial for the murder of one of the store employees were both overturned by the Mississippi Supreme Court due to prosecutorial misconduct. And a subsequent trial for all 4 murders resulted in conviction, but this was also overturned for racial bias by the prosecutor and jury selection. Remember, I talked about that on the list. Another 2 trials ended in mistrials. And then on June 18th, 2010, a majority white jury in his 6th trial convicted Flowers of the 1996 murders and voted to impose the death sentence. Now, Flowers' case was one of 3 that the U.S. Supreme Court ruled were to be remanded to a lower court to be reviewed for evidence of racial bias in jury selection. And after the Mississippi Supreme Court reaffirmed the conviction, the U.S. Supreme Court again reviewed this case and overturned the murder convictions in 2019 with Justice Brett Kavanaugh. So we're talking 2019, not that long ago, writing for the majority. And in December of this same year, Flowers was released from prison for the first time since his original arrest, pending on a decision whether another prosecution would be attempted, a 7th trial. So you have prosecutorial bias, you have prosecutorial misconduct, you have the district attorney picking all white juries. And you can see here, this is a perfect example. And there aren't many, as I mentioned, but this is an example of prosecutorial bias. So I hope that kind of, and you can read a lot more about the Curtis Flowers case. Okay, so let's kind of move on a little bit, and let's talk about some different terms, or what they call suborning perjury, and jailhouse informants. Okay, and we'll define some of these in a moment. Now, Model Rule 3.3a, so these are the rules of evidence, rules of criminal procedure, etc., forbids an attorney from knowingly allowing false evidence to be admitted. Now, some argue that knowingly is too strict of a standard because prosecutors have argued that they did not know that the evidence was false. So, I mean, you have to think about this as I read it. And some argue that an objective negligence standard should be used instead. So when a prosecution witness lies, okay, perjures himself or herself, the prosecutor then has basically a duty to bring it to the attention of the court if they knew. And so the question is, how do you know that they knew, right? So these are, some kind of gray areas. And it's a little bit of a quandary, and we'll kind of go a little further in a moment. But, like a defense attorney's quandary when a witness commits perjury, a prosecutor must also take steps to avoid allowing false testimony to the stand, right? And the prosecutor's role is the easier one because there are no conflicting duties to protect their client because they're prosecuting. They don't have a client to defend, right? And when a prosecution witness, again, perjures themselves, that prosecutor has an affirmative duty to bring it to the attention of the court. So, kind of keep in mind that, if you recall from chapters 5 and 7, that the prevalence of testifying by police officers is unknown, but many believe that it is widespread. And I don't think I enunciated the word correctly. The word would be kind of stretching the truth, or what they call slang would be testifying. Okay? Researchers, observers, and especially defense attorneys believe that this stretching the truth, or what we call testifying, would not occur as much if not for the passive acceptance of the practice by prosecutors, meaning that they're not holding their witnesses as credible as they should be. And hopefully that kind of makes sense, right? And I kind of think it does. And it doesn't necessarily have to be a police officer. It can be an expert witness. It can be a jailhouse informant. It can be anybody. But sometimes if prosecutors become passive, then they might allow certain things to happen. Now, I spoke a moment ago about, expert witnesses. Misconduct also occurs when prosecutors intentionally use scientific evidence that they know isn't correct or they know to be false. And prosecutors may also bolster a witness's credentials, basically to allow him or her to make what they call gratuitous and unsupported claims on the witness stand, such as, to state something like unequivocally that fingerprint, hair, or lip print was the defendant's, when really it's hard to say that unequivocally sometimes. Does that make sense? So they kind of bolster this person up and make them look so, perfect and academic and knowledgeable, etc., that everybody believes exactly what that person says. Now, again, that's why they're experts, and the judge will decide whether that particular expert has the expertise to testify as an expert and give an opinion. But the prosecutor can also bolster this. So there is a process. Typically it works just fine, but sometimes it can be pushed into kind of the gray area, if you will. Now, kind of moving on a little bit with this, but staying in the same thing with expert witnesses, prosecutors have had experts suppress information that may have been favorable to the defense and not put it in their report or not conduct tests that might be helpful to the defense. And sometimes the reports are provided, but delay is used to kind of undercut the ability of the defense to use that information. So they might deliberately, what's a good word, drag their feet in order to, get close to a deadline, and they turn it in right at the ninth hour, minute before it's due, etc. But that doesn't give the defense much time to look at it. And then also in closing arguments, prosecutors may also overstate the expert's testimony so that it is basically consistent with and becomes matched. So they try to kind of clean things up and make it match with maybe the physical evidence. And that's something that really shouldn't occur. Although, again, understand they're supposed to prosecute the case and use only the facts, and they are supposed to do their best, but they're also supposed to be very forthright and very honest, etc. So kind of enough on that. All right. And one of the most common charges that are basically leveled against a prosecutor would be failure to disclose evidence. Remember I gave you those terms, exculpatory. So from a duty to reveal exculpatory evidence, that's evidence in favor of the defendant. It doesn't mean that it will clear them or show they're innocent, but it's in their favor. And we're talking about a Brady violation, not the Brady Bunch, if you're old enough to know what this show is. It's the Brady versus Maryland case in 1963. And I'm not going to go into detail on the case, but it's a super important case because, again, it does form the basis for the prosecutor having to turn over to the defense any evidence in favor of the defendant. And they call that exculpatory. Now, prosecutors who engage in these types of acts, we're still talking about Brady violations, not only risk losing the case that they're working on right now, but they also lose credibility and they undercut the trust and faith that we've placed in them in the justice system, if you will. And again, it's the Brady versus Maryland case. It's 1963, and have a link to the case that you can click on right here, and you can take a look at it. And OYA's is a really good website to look at certain U.S. Supreme Court cases because the information is short. It tells you what the issue of the case is. It tells you which justice voted in which way, and then the conclusion and the outcome. So a really, really good website. Okay. So now let's turn to judicial misconduct. We've looked at defense attorneys, we've looked at prosecutors, and now we're going to kind of turn our attention to the judges, if you will. Now, public exposés of judicial misconduct are really super rare, okay? But they do occur. And typically, in this type of misconduct, neutrality is questioned when judges voice strong opinions on issues or cases. So some judges might be a little overzealous. You're supposed to be neutral, in the middle, but sometimes the judges basically overvoice these super strong opinions on issues or cases because they're bringing their personal opinion into a case. And with that, a judge may recuse themselves, which means remove themselves, if he or she has a vested interest in the issue or one of the parties involved. Okay? And one of the kind of interesting cases that is outlined in your textbook, and it's a really good case, is the case called Operation Greylord in Chicago. It took place way back in the 80s, and because of this FBI investigation, 92 people were indicted, including, get this, 17 judges, 48 lawyers, 10 deputy sheriffs, 8 police officers, 8 court officials, and a member of the Illinois legislature. So, and you can kind of look up the rest if you want. It's Operation Greylord. But this shows you that, and this is back in 1980, and sure, it's a big city, Chicago, but things happen, and we know this. Okay, so let's kind of keep going with misconduct. So we talked about the fact that a judge can recuse themselves. Now, often the mere impropriety or the appearance of wrongdoing or impropriety is sufficient to warrant a recusal. And also lack of courtroom decorum, meaning proper procedures, etc., could in extreme cases represent judicial misconduct. So there's a lot of different things for us to kind of think about when it comes to misconduct. And I talked about Operation Greylord. So a really good case to kind of look at, but you can, look at how many people were involved in this particular case, if you will, this investigation conducted by the FBI. And, there are smaller type things, right? Where you have this judge under fire. For here you have a, judge under fire over stunning scene, ordered sheriff to shock the defendant, to tase them. So, there are some misconduct things, right? And not just these big, huge things. There's, and not that this isn't a big thing, but I kind of wanted you to see how, I guess, diverse misconduct could actually be. Okay, what about this picture? Taping a defendant's mouth closed during a trial. Now, the better way might have been, if I'm going to Monday morning quarterback and I'm not in the courtroom, etc., would be to have the defendant removed if he can't be controlled, instead of what you're seeing right here in this particular picture. Okay, so most judges strive to fulfill their role with integrity and honesty, taking care to protect the appearance and basically reality of justice. And misconduct is alleged when judges do not recuse themselves or act in ways that give some preferential treatment. And attorneys and judges are prohibited from discussing a case outside of the presence of the other attorney. In some cases, neutrality can be questioned when judges voice, again, strong opinions on certain issues. And we know that everybody has opinions on things, and sometimes because judges are people, they might have opinions as well, right? And they might have a strong opinion about a certain thing. So we do have to kind of understand that. Now, there is a prohibition on attorneys and judges, again, discussing a case outside of the presence of the other attorney. And this is called ex parte communication. And it's prohibited because it gives this, the one side preference over the other. It creates, and even if it was totally innocent, it creates the perception, if not the reality, but the perception of bias. And if a judge favors one side over the other, due process is really kind of, called into question. And this can include simple things like casual conversations, as well as more formal, exchanges of information. So, there are a lot of technical laws that kind of go, rules, if you will, procedures for even judges and attorneys. Now, if we look back at Chapter 9, we discussed the expectation that judges maintain unbiased position toward any issue that might come up before him or her. And in some cases, judges have been asked to recuse themselves because they have indicated to the news media that they already had opinions on a case before, the case was concluded. So what are, some forms of misconduct? So judges, for the most part, are like police officers and prosecutors. And Swisher, in an article or a text in 2009, lists and discusses various forms of judicial misconduct. And here's what they might include: failing to inform defendants of their rights, coercing guilty pleas, exceeding the sentencing authority, exceeding the bail authority, denying full and fair hearings or trials, abusing the criminal contempt power, ignoring probable cause requirements, denying a defendant their rights, and penalizing defendants for exercising their rights. So these are all things. And other forms of unethical behavior are less blatant. Okay. Judges have a duty to basically conclude judicial processing with reasonable punctuality. However, sometimes there might be widespread delays in processing, partly because of, let's say, the lack of energy to which some judges pursue their dockets, right? So these are all different types of possible misconduct. Okay, so this might be a pretty, well, you know what, let's go just a little bit further and then we'll take a break. So recall from chapter 3 and chapter 8 that wrongful convictions are increasingly appearing, in the news. And the factors that seem to be correlated with wrongful convictions clearly indicate that legal professionals must take responsibility for reducing the possibility of these miscarriages of justice, right? And it is important that we understand that this occurs. And it should be recognized that while sometimes prosecutors are implicated as pivotal, players in a wrongful conviction, in other cases, prosecutors have been pivotal in helping to free someone. So, that's important as well, right? Now, when wrongful convictions were compared with cases where a factually innocent defendant was indicted, but the prosecution was dropped or didn't result in conviction, researchers found that these factors influenced the likelihood of a wrongful conviction. And here are some reasons, if you will, for false convictions, meaning they've occurred due to. One could be state punitiveness, a weak case, errors in forensic testimony, age and prior criminal history of the defendant, an honest mistake, identity by an eyewitness, and also poor representation by a defense attorney. And, these are all things that we have to figure out. Other factors, could be things like bad science or things like that. But these are some of the general factors that contribute to these wrongful convictions. So this will probably be a good place to stop, and I really mean it this time. So this will conclude part 1 of chapter 10, and then we'll come back shortly for part 2.